Good afternoon. Today, I think, was the official opening of mud season for us farmers. I have a little farm in Palmer, Massachusetts. We raise sheep and goats. And I just couldn't wait till all the snow would finally melt, and I forgot that what happens after that is mud. And the Constitution sometimes is about as clear as mud when it gets explained by lawyers, particularly in law school. I didn't understand a thing they said. And I'm hoping that after today, we will have a whole different way of maybe looking at how to analyze. I'm going to let you get the periscope into the way that the United States Supreme Court looks at our rights. And we're going to do that using the proposed Parental Rights Amendment that has been proposed by Mike Farris, who is the founder of Homeschool Legal Defense, many of us have had some experience with that in the past. This amendment is a very, very bad idea, and I'm going to explain why. In fact, what it'll end up doing is it'll end up not only just harming parental rights, but it will probably do an awful lot more damage, and we'll talk about that. William Pitt the Younger, the Prime Minister of Great Britain, in 1783, when our Constitution was finally ratified, said, "Necessity is the plea of every infringement of human freedom. It is the argument of tyrants. It is the creed of slaves." And he said that because the Parliament wanted to extend a lot of benefits to the East India Company, the big giant corrupt adjunct of Parliament, where they all had huge investments and were reaping massive profits. And we're going to see that there's a great deal of, quote, necessity that has underlaid this push to get a parental rights amendment, particularly in the conservative movement. And I'm going to also talk a little bit about the 9th and 10th Amendments, because that is going to be our key to analyzing why this amendment is not a good idea for the Constitution. And if we have a few moments, I'm going to also relate this to the proposed Constitutional Convention and Mark Levin's push to try to get a bunch of other amendments into the Constitution similar to this one, and why those are also not the great idea. So why wouldn't a parental rights amendment to the Constitution be a good idea? I mean, most of us, if we have children or grandchildren, think, wow, parental rights are hanging by a thread. I mean, this is a disaster for whether you're a parent or whether you have children in a government school or just about anything you could do in society today. The Department of Children and Families is breathing down one side. The public schools are breathing down the other side. We have pushed parental rights into a corner. And so the impulse to do something about it, necessity, was great. But what they ended up doing is going to end up being a barrier to actual parental rights. And I'll explain why that works. How could a constitutional amendment to protect parental rights make things worse for parents? Well, what it's going to end up doing is going to be a pipeline to allow direct government action into families. Now, right now, there's this unseen Goliath, a great mammoth that's perched in the federal government called the Administration for Children and Families. It's part of, and the largest unit of, the biggest Goliath in the whole government, and that is the Health and Human Services Department. It has a $51 billion a year budget, and what it does is, behind the scenes, it operates to push out policies that the federal government wants to impose on families, but it does it through the states. It does not do it directly. It does it through all kinds of bureaus and directorates and apparatchiks and all kinds of other means. For example, when the Departments of Children and Families came into effect in the 70s, the Administration for Children and Families set up criteria whereby these various state child protection departments could get money as long as they structured their departments just like the Administration for Children and Families told them to do. So their influence is essentially, we'll give you the money and you have to do it our way. And that's the way it's always done in almost every single government program today. And I don't care whether it's farmers growing rutabagas or departments of children and families, it's the same pattern. If you grow rutabagas just like we tell you, you get the money. If you structure your highway department the way we tell you, you get the money. And everything is working that way. Now, the Administration for Children and Families, as well as the Department of Education, have a great deal of influence in what happens at the state and local level. But as of yet, at least, they don't have a specific and direct influence. Now, here's how this would work. If we put a Parental Rights Amendment into the Constitution, now what we have done is we've opened up a gigantic pipeline directly from the federal government to regulate parental rights. This is not what we want. Now, under the guise of seeming to protect rights, this is what's going to happen. I'd like to show you how this works. I have a little handout here for you, and on the front of it, it's a 3-page handout, the proposed Parental Rights Amendment. It has 5 brief sections, and I'd like to just go over how they've structured this. And as we do this, you're going to see, and it's the pattern of how you analyze the ideas that are being presented to us to try to get freedom is going to become apparent, and you're going to see sort of that we're going to rip away the fake cover and show you how the sausage is being made, particularly at the United States Supreme Court. The second page in the handout is really top secret stuff. As far as I know, it's never been seen. This is, I put this chart together. It's going to hopefully appear in the New American, but it's how the United States Supreme Court decides what rights to protect. And when you see how they're doing this, you're never going to look at the Constitution the same again, I don't think. Then the third page is the 9th and 10th Amendments to the United States Constitution, which are the actual ways to begin to restore parental rights. So let's take a look at Section 1 here. The liberty of parents to direct the upbringing, education, and care of their children is a fundamental right. Now, what does that mean? Fundamental right is code. It's legal jive code. And that means that there are certain rights that for some reason, even though they're all enumerated in the Constitution equally without distinction as to one being fundamental or not fundamental, they set aside certain ones and say, there's a hierarchy of rights. We're going to protect this one a lot. We're going to protect this one only a little. For example, and we're going to take a look at the chart in a moment, but property rights are not protected at all. Fundamental rights, unfortunately, even though it sounds like they may be protected, are not being protected. And a fundamental right is only protected this much, as opposed to a non-fundamental right which is protected this much. What the Constitution does not qualify the protection of these rights. It says Congress shall pass no law. That is not qualified. It's not ambiguous. It doesn't leave any opening to say Congress shall pass no law except for on campaign contributions. And Congress shall pass no law except for when we don't want prayers at local schools. It doesn't say that. It says Congress shall pass no law. And the First Amendment lists 6 rights which Congress may not interfere with. And again, unambiguously it says they may not interfere with them. But what the Supreme Court has done is they've come along and put together a 3-tiered approach to protecting rights. And the fundamental right is, there are certain ones that they just sort of pluck out of the air and say, poof, we think this one's fundamental, and this one isn't. Take a quick look at the second page with me a moment. And there's a couple of terms I'm going to define for you here. And again, this is going to help. So every time you hear your favorite blow-dried news personality speak about this stuff, you are going to have the inside story about how and why to understand it. Now, there's 9 little blocks here. On the top, we have the type of scrutiny of the rights, then a standard of review of the rights, that is, how the court is actually going to look at them, and then finally, the issues which fall under that category. Now, along the edge on the left, we have the 3 different levels that they very arbitrarily just decided to put rights into. So here we have now if you take a look in the top tier, that's a so-called fundamental right. If you look in the middle block, it says the government may infringe on a fundamental right if, and it lists 3 things. Number 1, if the state has a compelling interest in infringing on the right. Who gets to decide that? The state. So it decides, I think we have a compelling interest. Too bad, so sad, your right's gone. 2, the government's action narrowly tailored to address the problem. They're saying, well, you can only infringe if our infringement is kind of narrow and we don't go outside the mere infringement of the right to infringe on other rights and other things as well. And the 3rd test is the government's action has to be the least restrictive means to control the citizen's action. And the burden is on the government to show this, but nonetheless, they call this, and you can see on the left, a strict scrutiny test. Now, this is how the Supreme Court does every case without exception. If there is a free speech case, they don't stop and say, Congress shall pass no law. That means Congress can't pass that law. You're out of here. Denied. They don't do it that way. They say, we don't want to worry about whether Congress can pass a law or not. We want to see if the state has a compelling interest and they narrowly tailored it and they're using the least restrictive means. You will find no wording like this in the Constitution. But every case, 100.0% are done this way. So this is what I'm saying. You're now aware of how the insiders analyze constitutional rights. So now on the right, let's take a look at the issues which are considered fundamental. Content-based speech. What content-based speech is if I want to stand out there and say, save the whales, that's content. The right to a jury trial is considered fundamental. Warrantless searches, free press. And the second type of category are suspect classifications, like racial groups. Now, it is my belief that if this, I almost wanted to do this chart a little differently. I wanted to take that piece out and actually put it up above all of the whole chart and call it a supraclass or a superclass, because in reality, that is the one thing they do protect, almost fanatically, is racial classifications. If you're in a protected group, you're golden. And if you're not, you're not. So this is called the strict scrutiny test, and this is where this Parental Rights Amendment would like to put the eye of the Supreme Court to protect parental rights. So as long as, so here's how this is going to work out in reality. We have a parent who says, well, I want to teach my child my religious beliefs, and my religious beliefs include certain biblical principles that say that marriage is between one man and one woman, for example, just to pick out something. Well, that's hate speech, pal. The state has a compelling interest in ensuring that your child does not learn to be a hater. And we are going to enforce that. And if you continue to do that, our happy little State Department of Children and Families over here will be assisting you to get the correct thoughts in your child's mind. We have a compelling state interest. Of course we do. Why? Because homosexual rights are a protected activity. They're more fundamental than most other rights. So the compelling state interest, and we already start seeing this happening in commerce now, and probably a lot of you are aware of this, that should a person have a religious conviction against, for example, marrying a homosexual couple or providing wedding-related services, they can be prosecuted criminally and fined. This is where parental rights are headed if we make them part of our United States Constitution. The compelling state interest will come down on the heads of parents. And people will protest and say, but wait a minute, we're supposed to protect parental rights. This is what the amendment was for. And they're going to say, you don't understand. We have a compelling state interest. And that is, and when I say 100% of the cases, you won't find one that doesn't use that analysis framework. So it can be predicted with almost complete certitude that that is what would happen if we had a parental rights amendment. Now, just while we're here on the second page, I can show you that there's an intermediate test that allows the government to infringe on rights if it, quote, furthers an important government interest. Now, those are gun rights, for example, is in that category. Sex-based classifications, including sexual orientation, that is a lie. They really put them in the top. Even though they say they put it in the middle, it is not true. And then content-neutral speech. Content-neutral speech is there's a meeting down at the town hall next week. And then finally, the lowest level of protection. The government can come against anybody as long as they have a rational basis for doing so. Now, a rational basis test, a citizen cannot challenge a government law or regulation if the law is, quote, rationally related to a legitimate government interest, i.e. ensuring that the environment is not interfered with, that the wetlands are not interfered with, that public schools are this, or whatever, name your government interest, and they will find that there's certainly a rational basis for doing something about that important government interest. Now, this applies to property rights, for example, environmental regulations. In fact, all regulatory intrusions fall into that category, which is why it is so important what I think probably the last justice on the Supreme Court who really gets it said the other day, and that's Clarence Thomas. Mr. Thomas dissented in a very, very important case, and it was about something that really isn't that important, and it was about Amtrak, about whether Amtrak could pound some kind of regulation out. Being a non-government entity, they're sort of a quasi-government railroad. And Clarence Thomas went into a very long and scathing dissent, stating that, wait a minute, we have created this whole fourth branch of government, a regulatory state, and it is not found in the Constitution, and it is wrong. And I just wanted to throw my hands in the air and say, hallelujah, finally somebody says it. And it's great that at least somebody there gets that what we're looking at on this page isn't the right way to do things. So, and I think in some ways Scalia will join some of that, but not all of that. So going back to page 1 again, so if we look at section 1 in light of what we've just talked about here, the liberty of parents to direct the upbringing, education, and care of their children is a fundamental right. Now, if we put that in the Constitution, then government lawyers will say, well, we have a compelling state interest to interfere in your child's education. We have a compelling state interest to interfere in your child's thought so that he doesn't become a hater and all sorts of other things. And they will add and add and add to the list of compelling interests vis-a-vis your child. So section 2, well, I think we should go to 3 because 3 is kind of tied in with it. Now look at 3 here. Neither the United States nor any state shall infringe these rights without demonstrating that its government interest as applied to the person is of the highest order and otherwise served. Now, that's code for the strict scrutiny test being the fundamental right. Okay, that's what that's code for, and anybody that does constitutional law would immediately recognize those words because that's sort of the code words that all the lawyers use. But look what it doesn't do. It doesn't hold that government interest at the compelling interest level, does it? They could take that whole chart tomorrow, because it's completely invented out of absolutely nothing, and they could move it down a notch. And they could say, well, the highest protection that you're going to get for any right in the Constitution is now rational basis. If there's even a rational basis for our government to interfere with your rights, we get to interfere with them. Because all it says is the highest one available. And since nothing is holding that fundamental right to the place that it now has, which is already very weak, they could weaken it and weaken it and weaken it further, as much as they wish to weaken it, and there would be absolutely nothing that any of us could do, because now it's in the Constitution. And they would go, you wanted it. And this right here is the United Nations thinker's dream. Okay, this is, if you gave this to the people that now run our current United States government, you would be giving them a gift that they would never, they would scratch their heads and say, why are these people doing this? They've given us everything we need. So going back to 2, the parental right to direct education includes the right to choose public, private, religious, or home schools, and the right to make reasonable choices within public schools for one's child. Don't you like that nice word, reasonable? Now, as my friend Mr. Allen, who's an attorney here, knows, the word reasonable has made more lawyers more money over the years than any other word in the English language. Reasonable. What is reasonable? Well, unfortunately, there would be cases virtually approaching infinity to argue about whether it was reasonable for the government to intrude in this way or this way or this way, and if past precedent, you know how they say on these commercials, you know, the past precedent doesn't guarantee future results. In this case, it does. Okay, it does guarantee future results. We would be losing our fundamental parental rights to those who argue, well, that's completely unreasonable. You can't teach hate. You cannot teach this. You cannot teach that. We certainly can't allow your child to pray, or you know, the little kid, the little 6-year-old who did bang bang, you know, and got thrown out of school. These kinds of things will intensify under the Parental Rights Amendment. It is virtually certain that that would happen. Section 4, this article shall not be construed to apply to a parental action or decision that could end life. Now, this one's puzzling, because all of us who at least are affiliated with the Birch Society knows that we have a very, very unshakable commitment to life. And that's one of the attractions that got me to join in the first place. Because that's one issue that to me is the barometer of almost all other issues, as to where you stand on that one. And look at, now this may seem innocuous, this may almost seem to preserve life, but let me tell you what Mr. Farris said. He said, I put this in there so that it wouldn't offend the liberals. I'm quoting almost directly from Mr. Farris, who wrote this. The reason for that is because what it really does is, for the very first time, it does not permit, on a constitutional level, somebody from stopping an abortion. Now, why am I saying that? Well, here's how this works. Right now, we do not have a law about abortion in the United States Constitution. In fact, we don't even have a federal law about it. We have 7 guys, most of whom were appointed by Republicans, by the way, who in 1973 decided to overrule state laws prohibiting abortion. That's what Roe versus Wade came about in 1973. There were state laws. This was a matter that was regulated by the states. And in one court case, that United States Supreme Court majority overrode all those state laws. Now, right now, we still have the moral high ground in a sense. Those of us who have said this is not right, and we're never going to move an inch, and we never will move an inch, we still have that moral high ground. We've if we put this Parental Rights Amendment in, we've now ceded it, and let me explain why. This article shall not be construed to apply to a parental action or decision that would end life. All right, scenario. Boyfriend, girlfriend. See it all the time. Girl wants to go to the clinic, terminate the pregnancy. The boyfriend doesn't want to do that. The boyfriend wants to have the child. It's not his body. He can't do anything about it. She goes and has the abortion. Here, we now have codified in the Constitution for the first time, it's a glancing reference, but at least it says that constitutionally that boyfriend has no right to stand. He has no parental right, let's say, to stand for his child and save that child from death. So I think that this would be, it's not fully developed in that language, but you know how things work when they're put in the hands of the United States Supreme Court. And finally, Section 5. No treaty may be adopted, nor shall any source of international law be employed to supersede, modify, interpret, or apply to the rights guaranteed by this article. This was specifically referring to the UN Treaty of the Rights of the Child. If you've read that, and I urge you to, it's not too long, you can read it, and it's horrifying. Essentially what it does is it turns families on their head. The children are now in charge, the parents are hapless fools, and if the child doesn't like something the parent does, the child now can report it to the local UN authority or whatever, and SWAT teams will descend on the house and take the poor child out and put them in a foster home where they won't be so oppressed. And I'm not too far off. I know this is a sort of a hyperbole, but we're not too far from that at this point. The type of law that I have practiced for about 20 years dealt primarily with that sort of scenario happening on the state level, and it happened frequently. If an older teenager wants to get out of a home, all they have to do is report, falsely or not falsely, that somebody in the home is abusing them, and they will be removed from that home. What this will do is this will take it up a notch and allow the United Nations to be involved if that treaty were to be passed. So the impulse here is to say, well, we don't want that to happen, so we do not want this treaty to go into effect. If that did go into effect, this provision would stop the treaty from being effective vis-a-vis families. But this sets up a dissonance in the Constitution itself. Here's why. We already have a way to not have a treaty. It's Article 2, Section 2. The United States Senate is in charge of approving treaties or not. And if the United States Senate approves that treaty, it unfortunately becomes part of our law. So we will have a contradiction built right into the law. We will have a provision that says that the UN can interfere with parental rights, and we will have one that says it can't. And this is going to be very difficult to resolve. I believe what we should do is we already have a way to stop the UN Rights of the Child Treaty. It's called the Senate. And that brings me to the point of the third page here. And how in the world can we really preserve parental rights in the correct way? The means do not justify the end. We've done this too much. How many times has the politician stood up there and said, oh, I'm going to promise this, I'll promise that. We vote for them and then they don't do it. Now, we already have in our Constitution an amazing two sentences here in Amendments 9 and Amendments 10. And they've been sitting there in mothballs in a dark room somewhere, inoperable. But all we got to do is dust them off, take them out of the room and set them back on the shelf where they should be and put the spotlight on them. I'd like to explain briefly how you can understand the difference between the 9th and the 10th Amendments. It's always been fuzzy to me till I sort of figured it out this way. It's real simple. The 9th Amendment deals with rights. Notice how I've underlined the word rights. That isn't in the original. I put that there. The 9th Amendment deals with rights. And the 9th Amendment says people you have all the rights, all of them. Now, we've listed some in these first 10 amendments, these first 8 amendments before these, but that's not all of the rights. You have all the rights, including the ones we wrote and including all the ones we didn't think of or we didn't write. They're all yours. We can't interfere, the government cannot interfere with any right unless in Amendment 10, and this Amendment 10 is about powers of the government. So 9 is the rights of the people, and they are wide. Amendment 10 is the powers of the government, and they are narrow. So Amendment 10 says, you, government, will only have this little tiny sliver of stuff that you can do. You can make post offices, okay? You can print, you can use silver and gold coins. You can set up federal courts. There's certain enumerated rights that are given to the United States government, and they're very few. There's hardly any. You wouldn't know that by today, of course. But what this is saying is all the rights that you have in Amendment Article 9 are there, only narrowed slightly by the ones that are enumerated in the Constitution. So, rights and powers. Now, how does this work for parental rights? Well, this is fairly simple, and I'm going to urge you to take a look at the difference between page 2, with that big structure of how the United States Supreme Court analyzes rights, and page 3, and that's how the Constitution analyzes rights. Let's stay on page 3, and I'll explain how we do it. Okay, so somebody comes along with the bright idea, Parental Rights Amendment. Yay, we got to preserve parental rights. Necessity. We got to do something. Here's what we look at. All right, does the federal government have a right somewhere? Let me look through every single article. Let me read every word in the thing. Does the United States government have a delegated right of some sort to have anything to do with parental rights?
No.
No. Oh, okay. Well, then we don't want our Parental Rights Amendment. We already know that the United States government can't interfere with parental rights. It's already done. Why do we need to put another Parental Rights Amendment? We have one. Article 9 and 10 are our Parental Rights Amendment. They're already there. We don't need a second one. It's a very common trend in the law today to do this all over the place. For example, gun rights. Look at all the gun laws. We already have a gun law. It's called Article 17 in the Massachusetts Declaration of Rights, and the federal government is restrained under Amendment Article 2 of the United States Constitution. So we're done. We got it. We don't need all this other stuff, but they like to keep putting more and more and just piling it one on top of the other on top of the other. So now typically, because of this tendency to do this, what happens is, if you're charged with a crime today, say you go in and you stick up the 7-Eleven, you'll end up coming out of there with about 10 gun charges, plus the robbery. But they'll get you. Well, you didn't have an FID card, and your serial number was taken off the gun, and you didn't have a license to carry, and you have ammunition, and on and on and on and on. So typically your indictments are endless because they just keep adding law upon law upon law. All we really need to understand when we take a look at something like this Parental Rights Amendment is, well, is this a right I retain by virtue of Amendment Article 9? Or is it a power that the government has by virtue of Amendment Article 10? Pretty simple analysis. I know it sounds simplistic, but they wrote it fairly simply. And I don't think we have to really overcomplicate it. Thus, parental rights are something that is left to parents. Now, certainly if a parent commits a crime against a child, that's a whole different situation. But we have law enforcement to take care of crimes. If there's an assault, a sexual offense, we have local law enforcement who can deal with and is equipped to deal with, and a court system that can and will deal with those offenses. But all of this other stuff is not appropriate matters for government. So this brings up finally this whole idea, and many of you have probably heard the talk show host Mark Levin, and many of you probably are aware that he has proposed a series of 11 amendments he calls them the Liberty Amendments. Everybody heard of that? Everybody heard those things? Well, you know, this is exactly the same thing. If you go down through those Liberty Amendments, you can analyze these in the same way, and you'll go, whoa, wait a minute. You know, on the surface it looks good, but do I want to put these powers in the hands of people who analyze things the way that that second page does? Well, I'm not sure I do. Now, maybe repealing the 17th Amendment, that's maybe the only one that I like out of his 11, because that puts, the 17th Amendment is where we started directly electing senators instead of having senators be chosen by the state legislatures. That would be a good power to return back to our original Constitution. That one actually says, okay, we're going to go back to what it was and restrict a right of the government. But most of the rest of them don't. How about require a balanced budget and limit federal spending and taxation? What this would do, for example, and if you apply the same analysis, this would codify for the first time the opportunity for the United States government to legitimize spending trillions of dollars. And it would be right in the document, because all they'd say is, well, okay, we're just going to raise the taxes. Guess we got it. It says it right here. So they wouldn't stop the programs. You think they're going to get rid of Health and Human Services? They're not going to. They're not going to get rid of Medicaid. They're not going to get rid of federal housing projects, et cetera, et cetera. They're not going to get rid of them. So what they will do is they're going to say, well, we now have to have a balanced budget. Guess you guys are going to just have to pay a lot more. In fact, it's constitutional, and the United States Supreme Court will apply their little analysis out of my little chart, and yep, certainly a compelling state interest to us. Looks good. And we have, almost all of these, if you go right down here, are going to be the same sort of a thing. Allow states more easily to amend the Constitution, require photo ID to vote, define a deadline to file taxes. I mean, these are not things that should be on a constitutional level. We one time before took a vice-based social issue, i.e. alcohol consumption, and made it part of the Constitution. And we did that in the 18th Amendment, and it got repealed a few years later under the 21st Amendment. Hopefully we've learned from that. You don't put passing political issues instead of transcendent issues into a Constitution. Those sorts of things need to be the subject of laws made by Congress or state legislatures or whatever it would be. But you don't clutter up your transcendent document, which aspires to fundamental things, by putting passing things in, like voter ID. Okay, you just don't do that. And so I would suggest that as you hear well-meaning people who say, look, we got to do something about this, necessity, you know, but unfortunately it really is the plea of every infringement of human freedom, because should this pass, or should these sorts of things pass, we're going to see our freedoms actually restricted rather than expanded. It seems so counterintuitive, I guess. But I hope this has been, you know, given some insight into how they actually do this stuff. And this take-home piece here, you can put it somewhere, and next time Mr. Levin starts jabbering about this stuff, you can go down and analyze how it would actually work out in real life versus how the 9th and 10th Amendments would look at it. Thank you so much. Appreciate it.